The next matter to come before the court this morning, or a final matter to come before the court this morning, is In Re SR. Both sides will again have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you want to let me know when you get started on keeping the clock, and we'll keep you apprised of the passage of time. The court's read the briefs, and we're ready to proceed when you are.
Thank you. May it please the court. My name is Neil Agrawal. I represent the appellant Rodney Reed. I'll actually reserve 5 minutes for rebuttal, Your Honor. May it please the court. Your Honor, I hate to be before the court today on this case. This has a very long and convoluted history. It is, I know it's been before, it's been controversial down at the trial court, this ruling, but the basic facts are the agency filed a complaint alleging abuse, dependency, neglect. They knew where the father was the whole time.
Well, did they really know where he was, or did they just know what state he was in?
They had an address, Your Honor, and he was served properly at the very beginning of the case.
I understood the briefs to suggest that they believed he was in Sacramento. In fact, he was in Vallejo. Those are two different cities.
Correct, but they, by the time of adjudication came, Your Honor, he was properly served in Vallejo. But that's not where the misconduct of the agency came in. After adjudication, Your Honor, when it came to disposition, the caseworker told the magistrate at juvenile court, and this is in evidence, we don't know where father is. And at the last court hearing before this court, the state conceded that they lied to the trial court. I'm sorry, they didn't use the word lied, they misled the trial court as to where father was. Father was never added to the case plan. This court said that is a violation of his constitutional rights, his statutory rights, and it violated the child's constitutional and statutory rights. So, permanent custody is vacated. There's never been a valid case plan in this matter, and we're going to reverse and remand for further proceedings. Well, when it got back to the trial court, on behalf of the father, I filed a motion to dismiss, saying, well, based on outrageous government conduct, lying to the court, 2, we are beyond 2 years. So, and I specifically cite in my reply brief, Your Honor, the statute of 2151, 415 D4, which says, no court shall grant an agency more than 2 extensions of temporary custody pursuant to Division D of this section, and, this is very important, Your Honor, the court shall not order an existing temporary custody order to be continued beyond 2 years after the date on which the complaint was filed or the child was first placed into shelter care. Well, we are now 3 years from the filing of that complaint. Now, if this, and all I'm saying is they have to dismiss and start this all over again. I am not arguing that they are without, that they have to be dismissed with prejudice and they can never refile again. That is not what I'm saying. They have to start this all over again based upon the convoluted history, procedural history that brought this case here due to the agency's actions.
Let me ask you a question. A statute talks about 2 years. Does that 2 years contemplate, and this wasn't raised by the state, but I thought about this when I read the briefs, does this 2 years contemplate a situation where an appeal and remand intervenes? And the reason I raise this is because we've seen something similar to this before in criminal cases where the appellant is raising this unreasonable time in which the court has taken for sentencing. And we held that, and it's not a situation where the person is convicted and then the court just sits around for 8 months before imposing a sentence. But it was raised in the context of the conviction and then an appeal, and then it comes back on, for example, post-release control. And we ruled that that time frame doesn't take into consideration the time when a case is up on appeal and goes back. And so my question is, do those 2 years contemplate appeal and remand?
I don't think so, Your Honor. The statute is very explicit. It says 2 years temporary custody of the agency. And I cited a brand new Ohio Supreme Court case, State versus Van Zandt. And there they talked about if a statute says shall or shall not, what does it mean? Here they said, use of the word shall not, this is on page 3 of my brief, shall not indicate that a statutory prohibition is mandatory. So, here the statute specifically says the juvenile court shall not continue temporary custody beyond 2 years. That is a mandatory order by the legislatures to the juvenile courts that if you are beyond 2 years, you cannot continue temporary custody. You must make a different dispositional ruling. Does the child go into the permanent custody of the agency? Does the child go into the legal custody of the parent or legal custody of a third party? If it's a PPLA situation, then it would be legal custody of the agency.
But I guess my question is, in the Van Zandt case, on its facts, did that include a situation where the 2 years encompassed an appeal and a remand?
No, it did not, Your Honor.
Okay.
I could not find any identical case law on the nature of these facts. Because again, this is a very unusual case. But again, if we follow the state's logic, and we say a dismissal is not proper, okay, up to today, there is still not that one valid case plan that involves the father that has been put into effect. There was one filed just before the filing of the appeal. I filed objections. The judge has not ruled on it, and while those objections are still pending, it's not been enacted or put into effect. So now we have 3 years. If this case goes back, we have a hearing on the case plan, and let's say the court adopts the case plan. Fine. At that date going forward, the child has now been in temporary custody of the agency for more than 3 years. And how much time are we going to give the father to reunify with this child before the agency may decide to file for permanent custody? They don't have to wait 12 of 22. They can do it on day 1. They can allege abandonment, they can allege should not, cannot, they can allege any number of grounds. Father has 2 years under the statute to comply with the case plan. First of 1 year and then 2 6-month extensions if you can show substantial compliance. But here, the agency may give him 0 time. Based upon what? The agency's actions initially and not including him on the case plan.
Well, wouldn't you have the option of objecting to that? I mean, that's speculative, but you have the opportunity to object and you have the right to appeal if that were the case.
That's true. What I would say is not speculative because the agency admitted at the hearing that we plan on filing for permanent custody. So that part's not speculative, but I agree, we can always fight permanent custody.
Right.
But again, Your Honor, if I object to the permanent custody and I win a third appeal, or win that appeal, the child may be in the temporary custody now 5, 6, 7 years plus. What does the legislature meaning 2 years means? Again, in the state's reply to the statute, they just said in re young. That was the only explanation, which was a 96 case from the Ohio Supreme Court that says a court has inherent authority to go beyond the 2 years. But the legislature has legislatively, which is in their discretion, overruled in re young. Why would the statute be amended to specifically say no more than 2 years if they did not disagree with the in re young decision, where children could languish in the temporary custody of the agency in that type of situation for years on end?
But a dismissal doesn't shorten the time period that the child remains in temporary custody, does it?
If there was a dismissal and a refiling, Your Honor, there's a new clock for the father, a new clock for the agency. Everybody would start afresh at that point. I would argue that temporary custody could not be used for 12 out of 22 for should not, cannot on permanent custody purposes, but they would get a fresh 2-year clock to keep the child in temporary custody of the agency.
Right, I understand. Perhaps the question is, does it lessen the time as the child is concerned, or does it lessen the time for the father to comply with the case plan that hasn't even been issued? In other words, I think is it not true that the legislature's mandate is so that children do not languish in temporary custody for a long period of time.
Yes, I believe so.
The dismissal of the complaint and a refiling of the complaint, if that were to happen, would not shorten the amount of time the child in this instance remains in temporary custody. Or
That is true for the overall time of this child, absolutely. But if we're talking about for the jurisdiction of this case before the juvenile court, with this case number, that would not be true. So I would agree, yes, every 2 years, the agency could dismiss and refile, dismiss and refile, dismiss and refile. The child could be in temporary custody for 18 years, but legally speaking, on that case, they've only been in temporary custody for a maximum of 2 years. So yes, there is no perfect situation, if I answered your question.
You're at that 5 minutes if you want to
Alright.
reserve.
So respectfully, Your Honor, I'd ask the court to grant the motion to dismiss or order that the trial court improperly is continuing this case, and I'll reserve the balance of my time. Thank you.
May it please the court, Heaven D. Martino on behalf of Summit County Children's Services, we are asking that this court affirm the decision of the trial court. Before I get into my argument in response to what was raised in the briefs, I just would like to note that at no point did the agency ever say that we committed some outrageous governmental behavior by lying to the court. It was very clear that there was a misstatement made by a caseworker with regard to the knowledge of who the father was and where he resided. That's not a part of this appeal. However, I feel I just need to correct the record to show that the agency did concede under the very limited circumstances of this case that there was plain error. I would also like to point out that the father in this case at no time cooperated, even though he said he would, with getting genetic testing here in Summit County. Father has not participated in the case plan. I believe if you ask counsel where his client was or the last time he talked with him, I would venture to guess, based on my understanding of this case, that father has still not been participating or attempting to re-engage with this child. The fact is that...
Let me just ask you this. How's that, is any of that in the record before us?
What's in the record is the same things that were on the record before. Appellate counsel was pointing out to the fact that his client should have the additional 2 years, which is, in my opinion, misleading the court that this father is active and engaged, and it's my understanding that is not what the record shows. And I would ask that the court just stick with what was in the record, not what he said or what I said, but I just feel that I need to, on my client's behalf, correct the statements that were made by Mr. Agarwal, because I don't believe that they're in the record, and I also don't believe that they're accurate. The fact is that this court remanded the matter back to the juvenile court because the case plan was defective. When the matter was returned to court, Mr. Agarwal started objecting and asking for the matter to be dismissed, saying that the court didn't have jurisdiction. He did not, in his written motion to dismiss, say that it exceeded the 2-year statutory time frame, or that because the case plan was defective, it was null and void, which somehow therefore negated the disposition as if it ever occurred. That statement was made in passing during the hearing on the objection when he said that he thinks the court has any jurisdiction to continue the case beyond 2 years. But it was a passing comment. It was not raised in the written motion. And there is nothing in the record to support this argument that this court knows what it intended when it remanded. The agency's belief is that the matter was remanded so that father could have an opportunity to be put on the case plan, and if he so chooses to re-engage and to work the case plan, that he be given that opportunity. If this court meant, when it issued its decision, that the agency had to dismiss the case because it was beyond the 2-year statutory time frame and that the defective case plan somehow nullified the disposition, then this court can clearly state that. But I don't believe that that was the court's position, and if it was, then obviously I would,
Well, it could be the situation that those specific issues were not before the court the first time it was on appeal. So perhaps the court doesn't have an opinion.
And that may be true as well. But the argument that he was raising at the trial court is that that was the mandate of the court, basically, is, the whole, the case plan that was defective, therefore the disposition is nullified, and that is not what it said. And I do believe that the court that has jurisdiction of these children in these dependency cases, neglect abuse cases, beyond the 2 years when there's an appeal. It wouldn't make any sense to charge that time essentially to the child. The purpose of having the children in the protective custody, temporary custody of the agency, is to protect the children, to make sure that they are eventually placed in a home that is going to be what is in their best interest. The
Do you
solution.
agree that In re Young was legislatively overruled by the 2151 415 D4?
I would argue that the idea that the courts can still have discretion on a dispositional order, that part of it was not overruled. I believe that the courts still have jurisdiction, especially when there was an appeal. And the fact of the matter is, in this case, what he's asking for is in contradiction to what he says the statute 2151-415D says. He's arguing that on dismissal we should start another case plan for 2 years, which would put this child in the temporary custody of the agency for 5 years. And it's clear that the reason why he's making this argument is he wants to do an end run around the first case where father did nothing. And he does not dispute the fact that father was served, that father knew there was a case going on, father didn't do anything. So he wants another bite at the apple to get another 2 years for father to complete the case plan. But he's really presented nothing, and there's nothing in the record to show that father even would do that. So who suffers? It's the child that suffers. He did not even allow the court to get to the point of adopting the case plan so that father could have the opportunity. Instead, he immediately filed this motion to dismiss. To me, the remedy that he's asking for doesn't make sense unless you look at it from the point that he's trying to get around what the legislature has mandated, which is that the children should only be in the custody of the agency for as long as is necessary. We don't want the children to stay in our custody beyond what's necessary. We want to reunify the child with a parent or in a kinship placement as soon as we can. The agency has no reason to keep this child in custody for another 2 years just to see if father is or is not going to step up to the plate. And I don't believe that the mandate of this court by remanding was so that it could be dismissed. Even if that issue was technically not before the court, when the court remanded it, the court could have said remand for purposes of dismissal. The court said remand for purposes of this, consistent with this opinion, which totally exclusively discussed the fact that father wasn't on the case plan, and under these very limited circumstances, father should have been given the opportunity to work the case plan. So that's what he was asking for in his first appeal. When he gets that opportunity to work a case plan, he files a motion to dismiss, and then comes before this court and says, I want them to dismiss and refile, because I don't want my client's child to be in the custody of the agency for too long, when he concedes that it's going to double the time that the child's in the agency. The fact that the agency may or may not have said that they were going to file for permanent custody at the hearing, one, is just speculative, even if that's what they said, and two, if the agency did say that, then this court can take that into consideration, that perhaps that means that father still isn't doing anything. Otherwise, why would the agency be talking about filing for permanent custody? So he has given this court no reason to continue this child in the temporary custody of the agency for any longer than is necessary for the case plan to be filed, to be adopted by the court, for father to have the opportunity that we all have agreed he should have gotten, not due to any egregious, outrageous government behavior or lying, which again, the agency takes exception to. That's not what's in the record. That is Mr. Agrawal's way of inflating what happened into something that is not true. It was a misstatement at best. It was not outrageous governmental lying. There's nothing in the record to show that the agency has done anything other than try to give this child what's in the child's best interest as far as placement and as far as custody with a family member or a kinship placement, if we can. Otherwise, what the goal is what's in the best interest of the child. And if there's no other questions, the agency will rest on its brief.
Mr. Gold, you have 4.5 minutes remaining.
Thank you. May it please the court. Your Honor, not to beat a dead horse, but this court's specific word was misled. The caseworker misled. And that was the word the court used. Now, they're saying misspoke means the same thing as misled. I totally wholeheartedly agree. Misled has an intention of lying, basically, or leading the court down a path when it should not have. That's a lot different than saying, well, we accidentally said something that was completely false. But that's not really...
Doesn't matter, right?
Right, it's not really relevant. Just to move on. The agency said, well, again, let me come up here and explain. What would my client do? I will tell you for a fact, Your Honor, my client has contacted me. He wants to reunify with this child. He wants to have case plan services. He has tried to attempt visitation. He's trying to do all that, Your Honor. He has not been able to. He's never been on the case plan. The case plan that was filed were defective for a number of reasons that had nothing to do with reunification. Now, we're supposed to have a hearing on that before it goes into effect. The judge did not schedule that, and she denied my motion to dismiss. Now, something I didn't say when I got up here the first time is, when you have an adjudication and there's abuse, dependency, neglect, that gives the court jurisdiction. At the next hearing, there is a dispositional ruling. At the dispositional ruling, what do you do with the child? You make a dispositional ruling placing the child, and you must adopt a valid case plan. That has never been done in the 3 years of this case. So now they're saying that, well, we just want another bite of the apple. In all honesty, Your Honor, if this case dismisses and is refiled, or the case continues, this child will remain in the agency's temporary custody the exact amount of time. It does not increase the child being in temporary custody one iota if there's a dismiss or refiling, or if the jurisdiction of the lower court in this case continues.
How can that be?
Because, Your Honor, if the case is not, the dismissal is denied, it goes back. I'm arguing my client still gets up to 2 years to work the case plan and get the child back. If it's a dismiss or refiling, he still gets 2 years to try to work the case plan and get the child back. So it doesn't shorten the time by keeping the child or keeping this case open. It remains
The court agrees with your analysis.
Right. But they're saying, well, my client, wants a chance to reunify and he wants a case plan. Yes, he does. He's entitled to that. And again, we have given him zero opportunity to get this child back. And the agency, for whatever reason, doesn't want to dismiss or refile because the statute mandates it. We really want a situation where the child's been in temporary custody of the agency for 5 years? So, respectfully, Your Honor, I think this case has to be dismissed based upon the statute in my brief, and I'd ask the court to reverse the lower court. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. We are adjourned until next Tuesday. Thank you.